my screen now. I wanted us to discuss mergers because, commercial transactions, it only has eight or seven topics. It doesn't have a lot of topics, as compared to these, as compared to these other units. Oh, as compared to these other units, yeah, it only has 7 to 8. I think 7 to 8 topics. Yeah, if I'm not wrong, should be actually. Is it 7? I don't have my course outline here at copy, but I think there should be 7 topics. Okay, what I'm trying to say is there are very few topics in commercial transactions, but now the problem is there are few, yeah, but they're extremely expansive. They're very wide, yeah. They have a lot. They're kidogo, but they have a lot. Okay, so ordinarily, what will happen is, um, let me tell you the truth. Hata kama unasomaji, you can never ever read everything in commercial. Hata ufanye nini, unless that's the only paper you're sitting. In fact, even if it's only paper you're sitting for, you might need 2 years for you to fully cover commercial transactions, like for you to read cover to cover of everything. Companies Act, I think that should be the longest act because it has at least 1,030 sections. Insolvency Act imetoka hapa hadi huko Mesopotamia. So they are really, really lengthy acts. At the same time, they have regulations. At the same time, there's so many nuances attendant to companies. It's impossible for you to read everything. It is not possible. It is not doable. It is not humanly possible, unless we're the alien. But what you do now, because it's a lot, you as you've always done before, Cindy, you take your course outline. That is what I was going to say. You take your course outline, okay, alafu by then just print it. Have your course outline hard copy. Alafu wewe unaenda topic 1. Okay, I've seen the course outline. Let me just show you what I'm trying to say for commercial, because I understand it's a lot. It's a lot, can be quite a lot, admittedly. So you take your course outline. Sawa. Oh Lord, I think my favorite lecturer left. Mm-hmm. I think he left. Yeah. Anyway, so I can't see his name there. This is the course outline for your cohort. So it has topic 1, senior companies. Let me tell you, companies is so wide. Every single day, when I go to the commercial department, there's a new problem. Yeah, and usually problems are, guys who have these problems are guys who were admitted in 1992. Like someone who was admitted 1992, they do not know whether a liquidator has power to distribute properties depending on contributions, or like there is a new challenge every day for commercial. Really, it's never in black and white. Sawa, especially companies. So wewe kitu haiko hapa, achana nayo. Because as I told you, your exam is usually set by, they usually, Sally puts up adverts and then guys are applied to become exam setters or exam markers. So those exam setters are not your lecturers. So the only way they would know, the only thing that you have in common with an exam setter is the course outline. So you can fully maximize, because this document is what they use to set the exam. Sasa kitu haiko hapa, wewe achana nayo, ignore, usiata iangalie, you'll waste your time. So you will start with companies, you go to main types of companies. So I don't know what material you're using for commercial. Like I don't know what notes you're using. There is commercial by Laibuta. Well, Lord, I don't think, honestly, I'm not discouraging you. Lakini you can't start reading a whole book right now. So if it's main types of companies, maybe we'll go to the Act, because the Act is straightforward. I think from sections 7 all the way to 9 or 10, they're about provides for types of companies. So you will read and then you leave it at that. Oh, story mingi achana nazo. So you will read types of companies and the characteristics there too. And then you go number B. You require to know execution of documents by companies. That is section 37 of the Act. So you go to section 37, read how companies execute. Unasonga. Sawa. So kitu haiko hapa kwa hii course outline usisome. Imagine, I'm telling you, because I know for sure, anything that's not here, you won't see it in that paper. Sawa. So use the course outline for commercial. It's quite a lot, and you could take a lot of time trying to read. You're reading so many voluminous things, and you're wasting time, which time you don't even have. Yeah. So let's discuss mergers and acquisitions now. So for mergers and acquisitions, well, it's actually again a very expansive topic. I'll try my best to say everything that I think is relevant. Albeit, I'll try to talk slowly. So for mergers and acquisitions, we are required to discuss documentation in mergers. So there is a term sheet. A term sheet usually is a roadmap for the transaction. There is an exclusivity agreement, NDAs, but we'll discuss those. You're equally required to look at legal due diligence. Has been tested so many times. I think seen 3 questions on legal due diligence. So legal due diligence is what you're supposed to do as an acquirer, yeah, or a company that is merging with another. And then you're equally supposed to do the disclosure letters. A disclosure letter is sent by the target company. Okay, let's leave it at that. We look at the content and then we come back at this and then see whether we've discussed everything that's there. All right. So let me project my screen now. Okay, so we are going to use this. These are the notes I used for the last cohort, and they prove they did prove to be sufficient. So usually a company will merge as a way of reorganizing. Sometimes, because especially right now with route to economics, things might be extremely tough. So you would merge with another in order for you not to feel the wrath of hard times. Because if you merge, goes without saying, then of course you'll be able to enjoy economies of scale. You know, the bigger you are, the better, because you're able to penetrate the market, you're able to enjoy more human resource, even in terms of maybe technology. Yeah, there is somewhat synergy, yeah, that helps you to stay afloat during hard times. So a company could merge, or what you would call a company reorganizing. So basically, merging is a company reorganizing itself. So for companies which reorganize, it could take a form of a merger. A merger is defined, you're going to define a merger shortly under Section 4.1 of the Competition Act. And then it could be an acquisition or it could be a takeover now. We will look at what a merger is and then we'll distinguish the three because they are different. Okay. So a takeover, okay, we can define them right now. So a takeover is an offer to acquire all the shares in a company or at least the controlling stake, 90%. So if you're taking over, it has to you have to have bought 90% of the shares in that company you want to take over. A takeover will become a merger if its duration exceeds 10 years. So under the merger threshold guidelines, if a takeover is more than 10 years, it becomes a merger. Otherwise, a takeover is a takeover. But if it's less than 10 years, then it's a takeover. However, the minute a takeover exceeds 10 years under the merger threshold guidelines, then it becomes a merger and usually regulated by CAK, as we'll shortly see. On the other hand, an acquisition is where you purchase 50% of the, okay, so a takeover will be 90% of the shares, and then an acquisition will be 50% the controlling stake, and then a merger, let's go to Section 4.1, we define what a merger is, and then but then I don't want to like tell you why a company will reorganize. I want us to look at the procedures of how a company merges. Okay, so it'll allow me to just scroll down. We define what a merger is, and then we look at the processes. Okay, so the laws applicable when dealing with mergers, there are quite many. There are sector-specific laws, and there are those general laws. Yeah, so we have the Competition Act. Competition Act, as we'll shortly see. I don't want to mention it right now, but very mildly, yeah, a Competition Act will apply to non-listed companies. So usually if it's an unlisted company means it is not listed on Nairobi Stock Exchange, and therefore it's a private company because private companies are not allowed to publicly advertise for their shares. So a public company, or rather a private company, which is merging with another private company, you'll use the Competition Act, but just hold that in abeyance. I'll make it make sense. And then there is the Capital Markets Authority Act, equally applies. This one applies to listed companies. Yeah. All the companies are in Nairobi Stock Exchange. Public companies are usually publicly listed companies. So Capital Markets Authority will apply to public companies which are merging. And then there is Banking Act. Banking Act is sector specific. So if it's let's say NCBA merging with a Gulf Bank, then you will have to go to Banking Act and see what sector specific laws we have regarding banks merging. And then Insurance Act will, of course, sector specific again. It will apply to insurance companies which are merging. And then the Companies Act, of course, will apply because all of these are companies, they're corporates which are merging. So there are other sets of laws. Okay, let me these two acts, the Competition Act and the CMA, they both of them they have some regulations, but Lord, we'll discuss them once we get there. But in the meantime, just try to remember these principal acts, majorly Competition Act and Capital Markets Authority Act. Yeah. So just try to remember those. Yeah. So I want us to define a merger first, and then we'll define classes of mergers. So a merger is defined under Section 41 of the Competition Act. Just a minute, I think I'll have to control find Section 41. So Section 41 defines what a merger is. This is page 8. Sorry. Sorry. Yeah, so let me scroll to page 8 to define what a merger is. So Section 41 of the Competition Act defines what a merger is. So if you're required to answer questions on mergers ordinarily, yeah, makes sense for you to start with Section 41. So it defines a merger as a situation where one or more undertakings, directly or indirectly, acquire or establish direct or indirect control over the whole or part of the business of another undertaking. And usually, it can either be through purchase or lease of shares. So when a company decides to buy shares of another, it could be deemed as a merger under Section 41. However, such purchase has to result in direct or indirect control. So let's say it is Safaricom which is purchasing shares from Airtel Kenya. If such shares are purchased by Safaricom, then Safaricom has to somewhat have a say, quote unquote, like they have to actually control the affairs of Airtel. So upon purchase of such shares, there has to be evident control of that company from which you've purchased the shares. It could equally be purchase of assets. You can decide to buy all the vehicles, all electronic computers, all immovables and movables of another company. So if it is purchase of assets, again, it has to result in change in control, either directly or indirectly. Okay. It could equally be acquisition of a controlling interest. So that is basically buying shares, yeah? And then you actually now have control. So these are the two main ways a company can either purchase shares, it can purchase assets, and upon such purchase, yeah, there has to be change in control of that particular entity from which you've purchased shares from. Yeah, I want us to look at the procedure of merging because honestly, these are the things you can easily look at them and understand them. Yeah, like the theoretical bits. Why would you merge? Why do companies merge? Mostly companies will merge to enjoy economies of scale. Now, so we are going to look at the process now, the process for merging. Hi. So there are two sets of procedures. There is one procedure which is found under the Competition General Rules of 2019. And this particular procedure in these rules, and actually these rules are an extension of the Competition Act, or rather, these rules are the subsidiary, is a subsidiary legislation to the Competition Act. So Competition Act provides you with a substantive law, and then the Competition General Rules provide you with a procedure when companies want to merge. Yeah. So these particular rules, we enacted them on sometime in December 2019. And usually there is a merger notification that you use. However, just hold it in abeyance, yeah? So first of all, before we start discussing the substantive process of merging, I want us to start with categories of mergers. because mergers are different. There are categories of mergers. So category number 1 is mergers which require comprehensive merger notification. This particular type of a merger is, there are circumstances, instances, yeah? So this particular, if your merger is a merger that requires comprehensive notification, you have to mandatorily inform CAK. Remember, we are discussing competition general rules. So the Competition Act creates a body which is called Competition Authority of Kenya. I think their offices are Ukoivyo, Westlands, I guess. Yeah. So, and they offer pupillage, by the way. So Competition Authority of Kenya is the body which is created under the Competition Act, and it is mandated with the task of actually overseeing merging processes amongst other other roles. Okay, so if your merger falls under this category A, you have to mandatorily inform CAK regarding your intention to merge. Category B is a merger which requires an exclusion application. There are those mergers you don't need to be allowed by CAK to merge. You know, one amongst the roles of CAK under the Act is to promote and safeguard fair competition in the national's economy. So sometimes you don't need to inform CAK. You don't need permission from CAK. You need to do an application called exclusion application. Yeah. To see what mergers fall under the category for exclusion applications. And then the third category are mergers which don't require any notification at all. So you need not inform CAK. In fact, CAK doesn't even need to know that you guys are actually merging. Yeah. So there are mergers which don't require any notification at all. There are mergers which require you to do an exclusion application, and there are mergers which require you to do a full merger notification. So there are those three categories of mergers, and it depends where you fall. Yeah, for you to know what type of notification you're going to do to CAK, you have to know where the merger falls. Like where is your merger? Where is your merger falling? Which category? So let's start with category number 1. Mergers which require. God, let me remove this color. I clearly love a lot of color. Life is too hard. You have to love colors. So the first one is full merger notifications. Let's start with that one. So for full merger notification, which you have to submit to CAK, there are these types of mergers. Number 1, a merger where the two undertakings, let's take Safaricom and Airtel. Yeah, both undertakings which are merging have a combined turnover, whichever is higher, of at least Kenya shillings 1 billion or 10 USD. 10 million USD. So if you're merging, if it's Safaricom and Airtel which are merging, and their combined turnover or assets are more than 1 billion, calculated, it's more than 1 billion, easily you will pick that from what you guys are drafting right now. Eh, na Joko, yeah. Hizo hesabu za balance sheet or financial position. So you will easily pick from such documents regarding what is your combined turnover asset of both entities. All right. So if both entities have minimum combined turnover or assets which exceed 1 billion, then you have to mandatorily notify CAK. Number 2, a merger where the target undertaking in Kenya is above 500 million. Now, there are two types of companies there. So if Safaricom is acquiring Airtel, Safaricom is, I'm saying acquiring, no, that's very fluid there. But if Safaricom is merging with Airtel and Safaricom is purchasing Airtel's shares, then Safaricom is the acquirer. Yeah. And then Airtel becomes the target. So the company which you are paying for their shares is the target. In this case, Airtel, which of course is smaller, is the target entity, and then Safaricom would be the acquirer. Yeah. So where that target entity is in Kenya. and its minimum combined turnover asset is above 500 million. A lot of numbers here. Yeah, you have to notify CK. I remember that morning before the paper. You know, I'm very, very poor with numbers. Yeah, so I looked at this thing like 15 times, Bana. Yeah, trying to remember. And then it was actually in that paper that we did. Yeah. So I kept trying to remember where was 1 billion, what was 500 million for. But because we have time, then you could easily remember that if a target undertaking is in Kenya and its asset is above 500 million Kenya shillings, we have to do a full merger notification to CK. And then thirdly, where turnover or asset, whichever is higher, of the acquiring undertaking is the acquirer, yeah, in this case Safaricom, is above 10 billion. So if you guys, like both of you, I mean, no, let's take that again. I think we could do a chart. I know these numbers are too many. Ama niache could downplay your ability to remember numbers. So if the acquirer is located in Kenya, because it could be a cross-border transaction, yeah? So if the acquirer is located in Kenya, is situated in Kenya with its principal place of business in Kenya, and its assets exceed 10 billion, then we have to notify CK. Now, I think I would easily remember if I were you. Of course, I will remember that a target undertaking is 500 million, and then an acquiring entity or the acquirer is higher. It's 10 billion. So, Lord, Akim, I wish I had advice for numbers. Really, that's the much I can tell you. When we angalia 2 in the morning before the paper, or maybe you guys are okay. You guys are young. You can remember. And then the merging parties are in the same market. Then you have to notify CK. Unless the transaction meets COMESA Competition Commission merger notification thresholds. Now, all COMESA countries, there's some regulations which govern acquiring entity and target undertaking between two countries which are both COMESA. So to avoid double regulation, if it's a cross-border transaction which is regulated by COMESA guidelines, then you don't notify CK. So unless you're notifying CK, unless you're notifying COMESA, then you have to notify CK if the acquiring entity has assets above 10 billion. If the entities are in carbon-based mineral sector, and the rights and the associated assets to be held as a result of the merger exceeds 10 billion. Please go on.
Will you kindly repeat the COMESA part?
Okay, we will discuss COMESA threshold. Now, there's some guidelines which govern cross-border transaction between COMESA countries, because let's say Safaricom here is acquiring a telecommunication company in Uganda, because these two entities are both COMESA states, then you have to inform COMESA. Yeah, there is an authority under those thresholds, so you have to inform them. So in such an instance where you are actually notifying COMESA, there is no need for you to notify CK, for the simple reason there will be double regulation, because you will now be notifying two bodies, yeah, the one under COMESA and CK. So if it's a cross-border transaction and you've met, yeah, COMESA thresholds, then you need not notify CK. But we will briefly discuss COMESA threshold for those cross-border transactions and see how they apply. So the third one, we've said you're in carbon-based mineral sector, and after you merge, the resultant entity will have assets for more than 10 billion. So what this means is it's Airtel and Safaricom merging, and the entity that will be formed from that merger will have more than 10 assets, more than 10 billion. Sometimes we have a merger called a merger by absorption. So in that type of a merger, Safaricom, we'll discuss types of mergers. I think it's important. Safaricom will just retain its name, you don't get a new name. But let's just finish the process first, and then we discuss those types of mergers. Could be merger by absorption, which means the acquiring entity just remains as with its name. Nothing changes in terms of the name. So if you're in carbon-based mineral sector and the resultant entity will have more than 10 billion in assets, then you have to notify CK. And then lastly, where COMESA thresholds are met and 2/3 of the turnover or asset is generated or located in Kenya. So you might be merging with an entity in Uganda. Yeah, so it's Safaricom here and another company in Uganda. Even if you've met COMESA guidelines, you have to notify CK if more than 2/3 of the assets are generated in Kenya. Yeah, so if more than 2/3 of your assets are generated in Kenya, even if you're informing COMESA, you have to inform CK. So 2/3 of your assets are generated in Kenya, you have to inform CK. And then let's look at the second one. So that's it. Now, you know, hapa, sasa ni just try to remember the figures, because most importantly are just the figures. This question was in that March paper. Guys were asked to discuss, you know, the category. And if you can't remember them, because they'll give you numbers, they tell you this entity has 20 million in assets, the other one has 1 billion, you know, what type of notification do you do? So you have to remember these numbers. Kuongea tu kweli, mi nilikram. Unajua kuna haja ni wadanganye. Mimi I don't know numbers. So whatever works bana, ukikram ni sawa. But it's too early to cram the numbers, unless that morning, which you might forget. However, you can easily remember the same time, sindio? Because I know you guys you guys are brilliant, extremely brilliant. So whatever you do, remember the numbers. If these entities, both of them, their combined asset is more than 1 billion, you have to inform CK. If the target undertaking is in Kenya and its asset is more than 500 million, you have to inform CK. And then if the acquirer is in Kenya and its asset is more than 10 billion, you have to inform CK unless you meet COMESA thresholds. And then if you're in the carbon-based mineral sector and the resultant entity will have more than 10 billion in assets, you have to inform CK. And lastly, if 2/3 or more of your assets are located or generated in Kenya, you have to inform CK even if you meet COMESA thresholds. Okay, so well. So just try to remember the numbers. The second category is exclusion applications. So exclusion applications, this is where they're called exclusion, but you have to at the same time give too much information to CK. So you apply to be excluded from full notification. Yeah, so you'll do an exclusion application. You don't do a full merger notification. When we look at that form, you'll see it has like parts. It tells you if you fall under this category, you go and answer questions in Schedule A. Don't answer anything else. If you fall in the first category, answer Schedule. Okay, we'll look at that form. Yeah, so let me stop jumping the gun. However, for an exclusion application, you equally have to do the application and give it to CK. Now, only 2 instances a merger will fall under exclusion application in the app. Number 1, where the combined turnover or assets of the merging entities, the merging parties, is in Kenya and is between Kenya shillings 500 million and Kenya shillings 1 billion. Okay, so it's 500 million all the way to 1 billion. So if that's your combined turnover, both the merging, both entity A and the entity B, or the target and the acquirer, then you have to do an exclusion application. You don't do a full merger notification. You do an exclusion notification, all right? And then if the firms, both entities, the merging parties, are engaged in prospecting carbon-based mineral sector, you have to do an exclusion notification irrespective of your asset value. So every single time you're in carbon-based mineral sector, of course, arguably, well, I think these entities enjoy a lot of autonomy. Yeah, they're not so many. So if you're merging and plus, really, this is almost, you know, carbon-based mineral sector, I think the economy is hinged on that. You see, if petrol goes, wait, is petrol from carbon? Okay, what am I saying? But I think it's related to petrol. If petrol and diesel go up, there becomes a challenge. Everyone is complaining. We can buy unga, you see. So if you're merging into the carbon-based mineral sector, doesn't matter what your value is, doesn't matter what your minimum combined turnover is, you have to do an exclusion notification to CK. So those two entities, honestly, sisi ni rahisi kukumbuka, si ndio? 500 million to 1 billion, number one. And number two, if you're in carbon-based mineral sector, hizo nazo hapo hakuna excuse. Personally, I will remember these two figures because they're fairly easy. Yeah. Please go on.
I think it's repeated. The carbon-based mineral sector is one of those that you listed in those that need to be notified.
Yeah, we did this one for carbon-based mineral sector. This one had a figure. So it will be mandatory it will be a full merger notification if you're in the carbon-based mineral sector and the resultant merger will exceed the assets the assets of the resultant merger will be more than 10 billion. That's the only time you do a full merger notification. However, if your assets don't exceed 10 billion, you have to do an exclusion notification. So it's this is the first one, the full one. It has a figure of 10 billion, and then the second one doesn't matter what your so ideally it means if you're not doing this one and you're in carbon-based mineral sector, then ordinarily you have to do an exclusion application. So if you don't fall in this category, you have to do an exclusion application for carbon-based mineral sector entities. Yeah, so that's the distinction. The first one has a figure, the second one doesn't have a figure. So if you're not doing the first one, 10 billion, you'll do the second one. Yeah. So those two. Yeah. So let's look at the last one. No notification at all. CK really doesn't even need to know your margin because there is one that is very funny. So the first one is if that particular transaction is taking place entirely outside Kenya. Of course, honestly, if it's taking place outside Kenya, why is it even in the act, in those regulations? You see, it's rather obvious. CK can't regulate a merging transaction in South Africa. So if that particular transaction is taking place entirely outside Kenya between two entities in different countries, then you don't really inform CK. You have no business informing CK because CK lacks jurisdiction over that particular transaction. And then where the combined turnover asset is below 500 million. So if both of you guys, if we calculate your assets, they are less than 500 M, you don't notify CK. You have no business of notifying CK. But remember, if you're in the carbon-based mineral sector, it doesn't matter what your asset value is, you have to do an exclusion notification. So no notification at all if the transaction is taking, albeit funny, it needs not be said, but it's fair. If the transaction is taking place outside Kenya, then we will do no notification at all. And then if our combined turnover or asset is below 500 M, then we need not do any notification at all. We just proceed and merge. And where the COMESA thresholds are met, then and at least 2/3 of your assets is not generated. Like that's the opposite of this point. This point here is the opposite. Yeah. So where you're already informing COMESA, you've met the thresholds in the COMESA guidelines, and your at least 2/3 of your assets are not in Kenya. They're not generated in Kenya. You don't inform CK, yeah, like at all. Yeah. So if you meet COMESA guidelines and 2/3 of your assets are not located or generated in Kenya, you need not inform CK. Okay, so those are the 3 types of notifications, merger notifications. I think we should discuss the documentation first, and then let's finish the process because we are already there. I want it to be coherent. So we finish the process and then discuss documentation. Yeah. Now, so what you do, there is a form. There is a particular form that you fill. That's the first thing you do if you want to inform CK. So you will first of all ask yourself, under which category do I fall? So you pick whichever is relevant to you, because that form tells you exactly what to feel depending on which category you are in. So you pick whatever category you're falling under. So in a quick minute, let me get that form. Just give me one minute. I'll check that form in a few seconds. I'm sorry I had not downloaded it. I have downloaded it, but I had not opened it. You know, every day, God, I've downloaded so many copies. Okay, let me project that form. I show you how it looks like. Lord, I equally can't see hands, by the way. I'm seeing the hand right now. The minute, you know, I'm on this other side of the screen, so it's not possible for me to see hands. So usually, just unmute. So Miss Mwangi, please go on. Please go on. Please go on. I'm sorry I couldn't see your hand because I am projecting the screen, so I can't see you guys.
Sorry, it was an old hand. I wanted to ask about that aspect of carbon-based mineral sector.
Yeah.
But you have clarified with the
yes, awesome.
previous.
Oh, it's okay, so it's clear. Sawa, Miss Mwangi. Thank you so much. Thank you so much. So competition, this is the document. It's called Consolidated Guidelines. The lengthy name, Consolidated Guidelines on Substantive Assessment of Mergers under the Competition Act. Yeah. So these particular guidelines, they are like pursuant to the Competition Act, or they are enabled by the Competition Act. Yeah. So there is a body called Competition Authority of Kenya. But they would check their website. They have good pupillage opportunities. Check their website. You could go there for your pupillage. So this particular authority, if you're interested with mergers, they have a department for mergers. They have so many departments for regulating so many things depending on their roles. Anyway, so this particular authority here, I will call it CK, is established under Section 7 of the Competition Act. And usually it promotes compliance to the Competition Act, including, regulating merging transactions. Okay, so I want to get the form for us. It defines the merger. It defines what a merger here is. Again, tells you what the authority looks at when assessing your merger application. Just give me a minute. I check that form. God, do I remember which part it's at? I might have to maybe control find. Let's see whether I find it. In these regulations, a joint venture becomes a merger if it exceeds 10 years. I'm not sure what regulation, but it's actually here. Just tells you if a joint venture meets, or rather it's more than 10 years, then it has to be regulated by CK. Like mandatorily, you have to inform CK. Good Lord. I'm trying to get that form. I might have it in a separate document. Just a minute. I really want us to look at the form. It's a standard form. Oh, it's in their website as well. So you can check it from there. Sindio, just give me a minute. I had sent it to that last cohort. Let me see from my Google Drive whether I can trace it. Merger notification form. Oh Lord. Okay, I found it. Let me download it. Yeah, it's in a separate form. Like it's not together with those regulations. So let me share that form I show you. So after deciding what category you fall under, then you fill this form. This is the form that you fill. It's called a merger notification form. Yeah. So this particular form gives you instructions actually. So it tells you it is issued pursuant to Section 4.3 of the Competition Act. And then here it tells you exactly what to write, like what to submit. So it tells you if a merger for exclusion, if you're doing exclusion notification, where JASA Schedule 1, only question 1 to 18, that's it. And this particular schedule. So don't write anything else. That's all you're going to do if what you're doing is exclusion application. And then it tells you merging parties do not operate in the same line of business. Like it tells you exactly where to go and what to fill. And then merger at above load. So it gives you categories, depending on where you fall. So it tells you what to fill, what schedule to answer. So it gives you guidelines here for schedule 1. You have to all the questions there have to be completed by the undertaking entities, by the merging entity, sorry. So together with your form. So that's the first document you need, a merger notification form. So you download it. Together with your form, you'll need the following documents. So once the merger has been proposed, before you even start, how much is the purchase price, you'll proceed and notify CAK. Otherwise, that entire transaction will be invalid. The entire transaction. There was a transaction, I think the company was called Asante. They merged, and then they didn't inform the CAK, and then they required a full merger notification. They didn't inform CAK. That entire transaction was invalid. It was void ab initio. Okay, so together with your form, you'll attach the following documents: a signed copy of the sale and purchase agreement. And usually it's because CK wants to see, how much are you buying at, purchasing assets, because remember, for mergers, there's someone who's buying something. So if you're purchasing assets or shares, then that goes into your sale and purchase agreement and the terms there too. Number 2, audited financial statements for the last 3 years, okay? And this is for both entities, the acquirer and the target. Both of you, you have to bring your audited financial statements for the last 3 years, yeah, preceding that date that you're applying. And then you'll equally need your latest annual report. Filing an annual report is a requirement under the Companies Act. Actually, it's in the course outline in the companies, yeah. So you have to file an annual report. Usually at your anniversary date is the date which the company was incorporated. So you will file an annual report on that anniversary date. So you have to bring your latest annual report. And so an annual report shows, basically restates, yeah, the mandate of the company, who are the directors, who are the shareholders, what types of shares are held by each of those shareholders, what's the aggregate nominal value of those shares, what is the class. So an annual report has the details, all nuances pertaining to a company and what exactly has happened that past year, whether there's been a change in directorships, a company secretary, shareholding. And then you have to equally bring a board resolution, because the only way a company makes decisions is through resolutions. So you see, you can't merge unless the company has decided to merge. So board of directors, they have to have sat down and discussed regarding a potential merger transaction. And that is where you're actually applying. Otherwise, you cannot purport to merge unless you have a resolution first. So you equally attach your board resolution and all other related documents that might be relevant for your merger. And equally, you have to bring a breakdown of employees. You see, if you're merging, some particular positions may be rendered redundant. It was so hard saying that. So some particular positions might not exist at all. So if you're merging with a company that has already has, let's say, a company secretary, honestly, you might not need 2 company secretaries. Or you're merging with a company that has already has a particular, skill set from particular employees. You might need to lay off some of these employees because you no longer need them, because now there is a new entity which might actually be doing something entirely different from what these employees were tasked, from the previous company or the target company or the other one, the acquirer. Yeah. So you bring a breakdown of employees and exactly how you intend to deal with any positions that will be rendered redundant. Okay. And then so that's it. That is what you provide together with your merger notification form. You attach a signed copy of the sale and purchase agreement, audited financial statements for the last 3 years, your latest annual report, board resolution authorizing the merger, and a breakdown of employees as well. Okay, now, once you submit this form, of course, you submit it. CK has an option of submitting it online. You don't have to, chukua bus when they go Westlands. You can submit it online. So after you submit this particular form and these documents, CK has 30 days to request for further information. So the minute you bring this form and maybe in CK's wisdom, it's incomplete or needs clarification on some aspects, then CK has 30 days from the date of receipt of this document to request for any further information from either of the company. they can request information from the target, or they could request information from the acquirer. So they have 30 days to request any clarifications or any further documents as may be needed. So once you have given any further details, maybe they request for any document, they can ask for anything. So after you've already submitted those documents, CAK has to respond. And before CAK responds on whether they've allowed your merger, there's some considerations. So CAK has a determination criteria of what mergers are we going to allow, or what mergers they're not proper, maybe because the competition will be unfair, they'll drive out these small entities. So there is a criterion for determining what mergers we are going to allow. I'm going to share with you the criterion. It's to be found under Section 4(6) of the Competition Act. So after you submit your documents, CAK does not make a decision, in a vacuum, okay? So they don't sleep and then wake up, decide this one you are allowing, this other one we won't allow. So it looks at the following before it allows your merger or maybe determines your application. So Section 4(6) has that particular list, okay? So it states, number one, the CAK will look at the extent to which the proposed merger is likely to prevent or lessen competition, rather the import of competition upon merging. You see, let's say it's a telecommunication company, super big, and then with another telecommunication company, which is equally doing very well. If those two entities merge, it means any other telecommunication company will be relevant. In fact, just get out, because if I'm looking for perfect example, but if two big companies merge, then ideally these other small scale businesses, they become invisible. So CAK will look at the extent to which you guys will affect competition, because CAK has a responsibility of ensuring that everybody is able to conduct business, in an extremely fair, conducive playground, fair playground. And then number two, CAK will look at the extent to which the proposed merger is likely to result. This is the point. Whether you'll acquire a dominant position in the market, of course, related to competition as well. So if you're acquiring a dominant position in the market, if you strategically, there are companies which in this country, there are a few companies which do a few things, like those very well-known companies. Yeah. So if a very well company merges with another very well-known company, then it means that they, of course, automatically they'll acquire a dominant position in the market. And of course, the import won't be very good for the rest of players in that same industry. CAK will equally look at the extent to which the proposed merger is likely to affect a particular industry sector. Because remember, when we were discussing, we said that those sector-specific laws which will apply to mergers. So if it's a bank, maybe one bank merging with another, then of course, how will that affect the banking industry? If it's an insurance company merging with another, how will that affect insurance nuances, okay? And then CAK will equally look at the extent to which the proposed merger is likely to affect employment, especially for those guys who are already there. You remember you have to submit your proposed breakdown of employees and how you're going to deal with those positions, which positions might be non-existent upon merging. So CAK will ask itself, because you might actually be jobless after the merging entity merges. So CAK will ask itself, how do you propose? Do you even have a proposal in the first place of how you're going to deal with this sort of employees? And then CAK will look at the extent to which the merger would likely affect the ability of small undertakings to gain access to the market. Of course, that act is called Competition Act. Yeah. So you can see CAK is big on effect of merging in terms of fair competition. So if you're merging and then unajua sasa hao wakulima wadogo, ideally they'll be left with, you see, as Kenyans, we like those big companies, like ordinarily. You don't want to get your internet from Airtel, you want to get from Safaricom. Yeah. Anyway, so the point is, if small undertakings will be affected, they'll have a disadvantageous position to emerge, then highly likely we might not allow your merger, because you know what? We want everybody to fairly conduct business, and as a result of your merger, they might not be able to do so. And then CAK will equally look at the extent to which the proposed merger is likely to affect the ability of national industries to compete in national markets. Yeah, we've talked a lot about competition. And equally, it will look at whether that particular proposed transaction is actually a merger in terms of the Competition Act. You see, you guys might be purporting it's a merger, because of your very fertile imagination. So you're like, this is a merger. But it's not a merger within the meaning of Section 4.2 of the Competition Act. So if it's not, Section 4.1. So if it's not a merger within the meaning of the Act, then CAK has no business dealing with that particular transaction. You see, it might actually be a joint venture. Merger. Yeah. So if that's the case, then CAK then deal with your application. So the first thing they ask themselves is this particular transaction even a merger in the first place? And then if you meet the threshold of what a merger is under the Act, now they'll ultimately consider these other criteria, substantively. So I think we've had enough of that. What CAK looks at. So CAK looks at your form, of course, now weighs it against Section 4.6.2, whether you've actually, like, what's going on. Will this be good, in terms of competition? What happens to small scale industry generally? So looks at all those, all these, yeah. And then if CAK is actually of the opinion that let's just allow this merger because we believe it's good for the economy, and maybe it's actually good for your for purposes. But then what happened to Big Four agenda? What was it called? This country is a total joke. Yeah, nothing works, nothing at all. I'm not sure what happened to Big Four. Did you even achieve any of those? That's why we have housing levy now. Maybe, I don't know. So if CAK looks at that and then it's decides to allow your merger, then once that merger assessment is completed, then CAK will communicate its decision to you. Usually, CAK has a merger and acquisition division which deals with merger applications or whatever sort, be it an exclusion one or a full merger notification. So that particular merger and acquisition division will recommend, whether this particular transaction is allowable. If it's allowable, then it will be the decision will be communicated to the submitting parties. Yeah, and actually approval can be revoked later on if CAK approves your transaction and then finds out, you submitted erroneous annual report. You actually submitted by an erroneous sale and purchase agreement. CAK can revoke your approval. Okay, if it is based on materially incorrect or misleading information. And if a merger decides to proceed without approval, then you're liable to a fine, and that transaction is invalidated. Like you never even did it, so you have to inform CAK. So that's the long and short of the process of merging under the Competition Act. Okay, so you prepare your form, you attach all those relevant documents that we've discussed, and then you submit them to CAK. CAK has 30 days to request for any further information as if needed. And then after requesting for such information, CAK sits down, the merger and acquisition division sits down and then considers your application against that criterion under Section 4.6. And if we are agreeable, okay, whatever decision we make, we communicate to you. Okay, and then approval can actually be revoked later if it was acquired based on materially incorrect info. And if you proceed without such approval and you're actually a merger within the meaning of the Act, then you will have to pay a fine and that transaction will be invalidated. Okay, I'm not sure that you have any questions regarding that process, but it's that short. That's it. Sasa, hiyo ingine hapo ndio it has a lot of days, like a lot of numbers. It has a lot of time. It's time sensitive, yeah. So this is the first one because I told you it's too tired. The process for merging is it's in two different set of regulations. Okay, so don't forget the first one that you've looked at is the Competition Authority of Kenya consolidated guidelines on how to merge for purposes of now. This will apply to private companies. If it's two public companies which are merging, yeah, you have no business of informing CAK. Sawa. Shortly, I'll tell you what happens for public companies. So usually, I was in a particular CPD event, and this discussion came up. Yeah, the discussion was to the extent, when do you let's discuss the other guidelines, then we discuss what I'm saying there for it to actually, for you to contextualize. Sindio. So there is the second merging procedure. Now that one is to be found under Lord. That name is lengthy. It's called Capital Markets. Capital Markets. Getting it? Capital Markets Takeover and Mergers Regulations of 2002. Yeah, Capital Markets Takeover and Mergers Regulations of 2002. You remember I had told us that you have two principal acts which govern merging, and amongst those was the Capital Markets Authority. Okay. One quick minute. Let me get it. Okay, so here we are. Okay, so this is the document. Yeah, not lengthy. The name is not very lengthy. I was exaggerating it. It's Capital Markets Takeover and Mergers Regulations of 2002. So these regulations, they govern mergers because the Capital Markets Act, that act, provides for mergers as well, like provides for merging as well. So these particular regulations, they'll only apply to listed companies. Let me get to the exact regulation that states that it will only apply to a listed company. Sawa. So you never, ever, ever, ever use these regulations when you're dealing with an unlisted company. An unlisted company means a private company. So if the company is not listed on Nairobi Stock Exchange, don't use these regulations. These regulations are only for listed companies. In fact, these regulations actually define here, they tell you that if it's to be a merger, then you have to acquire, as an acquiring entity, you have to acquire effective control. And then it actually tells you what effective control is, and tells you it is where you've acquired not more than, okay, just ignore that those numbers. Of importance is this: you've acquired shares in a listed company. So you see, it's very clear that this company which is being acquired and you're using these regulations, it has to be a listed company. Listed company, public. So if the company being acquired is not public, don't use these regulations. Okay, so these regulations will only apply where you're acquiring a public company, you're buying shares in a public company. So you use these regulations, okay? Otherwise, you don't use them elsewhere, I think. So if you read this particular regulations rather, they only refer to public listed companies. There is no mention of a private company whatsoever because it doesn't apply to private companies. It only applies to public companies. Now, there are two important people in these regulations. There is an offeree and an offeror. So an offeror is the giver. So the offeror, okay, Safaricom Airtel. If Safaricom is acquiring Airtel, it is the offeror, and then offeree would be Airtel. Yeah, but you can remember them as a target company and the acquiring entity. Yeah, so they're just synonymous. Okay, so I want us to discuss that process. I'll go back to those slides. Now, I think we'll have to keep coming back here. So the procedure is under part 2, but this applies to listed companies. It says no person shall make an offer to acquire voting rights in a listed company. You're going to use this procedure, and then tells you the percentages that goes down to give you, numbers. So it starts from here, regulation 4, part 2 of regulation 4. It has the procedure process. So I am going to share the notes because for purposes of moving fast, yeah. So I'm going to share, we are going to use the notes to discuss the capital markets takeover and mergers regulations of 2002. Of importance is to try and remember the numbers, the hours, the days. Okay. So the very first thing that happens, if this is what you're using, the regulations in the CMA, and then the authority created here in this act is called Capital Markets Authority. It's called CMA. Yeah. So this submission is like CMA is actively involved over here. There is no CAK here because CAK COCO in the Competition Act, and then CMA is in Capital Markets Authority Act. So we will use Capital Markets Authority. The other authority, we've left it in the Competition Act. So step number one, the offeror, within 24 hours of making a decision to acquire. So offeror is what we call the acquirer. Acquirer. Is that even a real word? I think so, it is. Yeah, it is actually. So offeror or the acquirer will announce that they have an intention to buy shares or acquire another company within 24 hours of making such a decision. So if the board sits and then decides they want to acquire, if Safaricom board, of course, Safaricom is a publicly listed company. Yeah? So if Safaricom sits and then they decide they want to purchase or to acquire Airtel, then they have to, within 24 hours of making that decision, publish a notice of intention to acquire. So it's basically step number one is just letting various persons, of course, who you're required to inform under the regulations, know you're about to acquire another entity, or rather you're about to merge with another entity. And it is strictly within 24 hours under Regulation 4. Now, this particular notice of intention to acquire is usually sent to number one, the press. You inform the press. Number two, you inform CMA, Capital Markets Authority. Number three, you inform Nairobi Stock Exchange. Nairobi Stock Exchange, because remember, we are dealing with listed companies here. Yeah. And then you inform the Commissioner of Monopolies. And then you inform the offeree or the target company, in this case, Airtel, if it's Safaricom, which is acquiring Airtel. So that first general step is basically letting every player, everybody who has a role, know that you're about to merge. So that's the first step, which is quite easy. So, just remember notice of intention to acquire, which has to be, communicated within 24 hours of making the decision to acquire, and it has to be sent to the press, to CMA, to Nairobi Stock Exchange, Commissioner of Monopolies, and the offeree. So at least 5 persons. Now, after doing that, you have to serve the statement of takeover scheme, or the proposed, you can call it the proposed purchase agreement. Yeah. So you have to send it to Airtel within 10 days from this date. Yeah. So the offeror serves the offeree with that statement within 10 days from the date of intention, the notice of intention, from the date of the notice of intention, from this step one. So within 10 days from the date you did step one, you serve the takeover scheme upon the offeree. So Safaricom will send the statement to Airtel within 10 days from the date of making this advertisement. I mean, from the date of the notice of intention. So if we did our notice of intention today, we have 10 days from today. That takes us to the first day you guys are sitting for your exam. So you calculate 10 days. So ordinarily, you have to proceed, and at least within 10 days from that date. I think I don't want to emphasize a lot because I might dilute the point. And then thirdly, so that's step number 2, and it flows like that. So here you have 10 days. And then step number 3, the offeree or Airtel, let's say Airtel, simply makes better sense for purposes of it, contextualizing it. So Airtel, within 24 hours of receiving that statement, will make a press notice, inform everybody who's here. They'll inform everybody who's on this list. Like we now repeat step number 1. Yeah, like they don't inform the offeree or the offeree. So Airtel, within 24 hours of receiving that statement, 24 hours, please take note of the time, the duration is changing. So within 24 hours of receiving the statement, we make a press notice, inform CMA, National Nairobi Stock Exchange, and everybody else, Commissioner of what? Commissioner of what? Commissioner of Monopolies. I'm sorry. And then step number 4, after this step, after the offeree informs everybody else that they've received the statement, then they'll proceed and submit. This is the offeror who's doing this. Step number 4. Offeror, we could say Safaricom offeror. So Safaricom will submit takeover document, this statement here. They'll submit this statement to CMA. Kumbe, it was actually there. It was there. You get the points. And so Safaricom will submit the takeover document to CMA for approval, and it has to be done within 14 days from the date step number 3 was done. Yeah. So 14 days from this date, we have to inform CMA for purposes of approving their takeover document. And then afterwards, CMA will receive that document, and then they have 30 days to approve or deny approval, okay, whichever is applicable, depending on maybe like what's you remember what CK was looking at, those things, your effect on the market, your effect on small scale businesses, whether you're actually a proper merger under the CMA and the authority has jurisdiction over the transaction, such things. So CMA has 30 days to approve, consider your application substantively, and then CMA will inform you regarding the approval. CMA will then communicate to you what they've decided. Yeah, the decision will be communicated to the submitting party. And then consequently, offeror has to serve the offeree within 5 days of receiving the approval. Yeah. So after they receive the approval, they have 5 days of informing Airtel. So Safaricom is told by CMA that, you know what, we've approved your transaction. So Safaricom has 5 days from the date of getting such information from CMA to inform Airtel. So they tell Airtel, hey, yo, SAP, we have the approval already. We should now proceed with the subsequent steps. Then what happens is Airtel will have 14 days to issue a circular to its members. And the reason why it's doing that, it's to basically indicate whether or not the board recommends that particular transaction, whether the board is accepting the terms in the statement, and basically what they could do. They're just discussing the nuances. So you see, Airtel is selling its shares. Shares are usually they're like personal assets. You know, shares are yours. In fact, after you die, your shares will devolve to your beneficiary, and you're selling these people's shares. Of course, you have to inform them. They have to be involved. Okay, you have to inform them that the transaction has been approved by CMA. Now we want to know what are your thoughts, and then board of directors informs members in the circular what are their thoughts. Of course, to provoke thinking by the members regarding the transaction specific details. So the offeree has 14 days to send circulars to all holders of voting shares, all its shareholders, and all relevant persons for purposes of discussing that particular statement. And then the offeror will keep the takeover offer open for acceptance for a period of 30 days. So what happens is we will give you time to discuss with your shareholders, yeah? Because at this point, a company doesn't even know that whether it wants to be acquired. The terms might be too hostile. They want to amend some of them, but basically you'll leave it open for at least 30 days as you allow the company to negotiate with the shareholders, discuss, maybe consult experts. You know, it's a heavy transaction. Consult anybody they think might be relevant, and you have to keep the offer open for acceptance by the offeree for at least 30 days. And then after 30 days, if you have not accepted the offer, then the offer closes and the transaction ends there. However, if you accept the offer, then we proceed and merge. Yeah, that is what will happen for a transaction under the capital market regulations. These regulations, let me show you what I did. Unajua hapa hakuna haja uteseke, si ndio? So there's no there's no happiness in struggle. So what you do, let me just show you. Let me just show you the trick, because unajua those guys don't even care. They don't care whether you've crammed or it really doesn't matter. Wewe bora umeandika kwa booklet. Yeah. So that is what really remembering is what really matters. I was telling you, you can't even test someone's intelligence depending on what they score at CLE. It's impossible. CLE, wewe kuna there is a particular person, you know, she used to go to Gate A on a daily. Yeah, kwa hiyo lib ya Gate A. But then I stepped foot for the first time when I was doing clearance at KSL in that lib. Yeah. So they used to go there, borrow book. They used to be there the time it's opening. In fact, kuna siku walifungiwa hapo ndani. It was that serious. So I go there in the morning all the way through. I sat there uko hivyo kwa gazebo. I reading bulky books, you know. Sunday ndio huyo amesoma. And then you see, now come exam time, they got 2 P's. So I asked them, kwani, you know what was wrong? Because if your reading should translate to your results. Now they told me they were not able to remember most of the things. They could see a question they have seen before, but they can't remember. Sasa unajua hapo ni wewe kumbuka tu, whichever way, yeah. You see, as long as you win the war, it doesn't matter your techniques. Wewe kumbuka tu. That's the only thing. That's your biggest responsibility right now, remembering. Unaweza ona hii vitu sahi unasahau hiyo siku. Wewe hiyo procedure una adopt ni sawa. Haijalishi, si bora uko admitted. So let me show you what I did. Maybe it might work for you, sindio? So I'll have to keep on checking. So I wrote down, because of importance is time as well. I mean, these numbers. So 24 hours, I wrote down 10 days. Good Lord. I wrote down 10 days. Like I wrote those days in how they are arranged. So I wrote again 2, 4, 14. You see these numbers? I wrote them down on a piece of paper. So I wrote 24, I wrote 10, I wrote 24, I wrote 14, I wrote 5, I wrote 14, and then 30. Because there are 7 numbers, like there are 7 digits. Okay, 7 different durations. So after writing them down, my only responsibility was to remember those days, those numbers. And easily, if you can remember 24 was the first one, somehow everything else on point 1 just comes to you. So don't forget those. That act is very time sensitive. Those regulations are time sensitive. So you have to remember them as they are. 24, 10, 24. 14, 5, 14, 30. But wewe kumbuka tu bana. I don't really know how to assist with numbers. but whatever you do, just remember whatever, but don't don't try to happy. So usijaribu kuandika kwa mkono. You know those guys are hawk-eyed, utapati, and then I think they're out to just get people cheating. Those guys, if you try to turn your neck, hata si kuturn your neck, ujaribu hata kuangalia hivi juu, huyo msa shafika hapo quick fast, unashanga huyu. Those guys are hawk-eyed. Don't even think about writing those numbers on your hands. Ukisahau uliza a neighbor, but just try and remember the numbers. Sindio? Okay, sawa. So let me leave it at that. So that's what will happen for capital markets regulations. Remember, it only applies to listed companies, which basically means public companies. And how the examiner won't tell you it's a public company. Sometimes they will, but other time, highly likely they won't. So how you distinguish between a private company and a public one? Usually it's how they end, the name ends. So if you read the paper and it tells you MWB PLC, it's a public limited company. If it ends with the words LTD, it's a private limited company. So LTD would be for private companies, and then PLC would be for public companies, because sometimes you might not see it might not be black and white whether it's a public or private company, but try to figure out both of these entities are private. Don't use these regulations. So if they're both private, just use CK, the process we've discussed in the CK. But if there is a public company here and you're purchasing shares from the public company, then it means you have to go to these regulations, Senior, because provides for merging of public entities. Yeah, I'm not sure whether we have a question. I'm not sure whether you have a question. I want to discuss documentation, like the documents involved, other documents involved in merging, during merging. Okay. You just allow me. Can you please just try listen to me, Cynthia? So the first document is, okay, let me just get it. Let me just get it. The first document is a term sheet. That's the first document. So we are discussing documentation. Good Lord, it has disappeared. A term sheet, we have to look at the page. So this is page 9. So a term sheet is also called a letter of intent. Okay, so you could say a term sheet, you could say a letter of intent. And usually a term sheet, which you've said is called equally be called a letter of intent. So these are documentations, yeah? A letter of intent, a term sheet usually will lay the foundation of what will happen. So it lays out, you could call it, lays out the entire transaction, like what will happen, the timelines. Yeah. So it's like a roadmap for the transaction. So it's usually the first record of a proposed merger transaction. And it forms basis of the negotiation of formal agreements. Usually, term sheets are not binding. However, you can have a binding clause. So the rule is that a term sheet is not binding, but parties could have because parties have autonomy to contract. Parties could have a clause, a binding clause, but generally it's not legally binding. So it lays the basics of the final deal. It's like what you would call a letter of offer for conveyancing, where you want to purchase a land, you ask for a letter of offer with the terms. So a term sheet or a letter of intent plays that role of laying out the basics of the transaction, which now leads us to the final deal. So it has things like purchase price, has closing date, has length of exclusivity, has approvals, yeah. Before entering into a term sheet, there are some considerations which you must put into place. They include commercial issues. So commercial issues are how much are you paying? How much am I getting? Am I getting value for my shares or value for our assets? And then you will also consider the issue of whether the term sheet is binding or non-binding. So if you want your term sheet to be binding, then you will have a binding clause in your term sheet. And then it could have issues like exclusivity you'll consider. You know, you could have a period of exclusivity. There is another agreement you're going to discuss. It's called an exclusivity agreement. But you could have exclusivity as a clause in your term sheet. So exclusivity means I am not going to deal with other people. I'm not going to offer my shares to any other person. I just wait for you to buy them. Or I'm not going to ask another person to sell to me their shares. So it could be reciprocal. I won't offer my shares to other buyers. And equally, you're not going to buy from any other person. You'll just buy from me. So exclusivity means you're exclusive. Like, don't do it. Don't deal with another person. Just deal with me. And then you could consider issues of due diligence, because remember, you as an investor, the person who's acquirer, you want to the acquirer, but the acquirer sounds so funny. Acquiring entity, that acquiring entity, you might purchase a company that is going under. So you proceed and buy assets, and all of them are encumbered. So you purchase parcels of lands, several, and then shortly, these parcels, all of them, they have been charged. All of them, people have borrowed, those directors have borrowed against all the property. They even have their movables, it is registered RUCO in PSR. Like, really, you've bought encumbered assets and you didn't know. So the issue of due diligence for an acquiring entity cannot be dispensed with. And the reason why you're really conducting due diligence ni kwa sababu utaoshwa. Kwa sababu if you don't do so, then we'll sell to you encumbered assets. We'll sell to you, maybe, those companies which do, especially those land buying companies. Yeah, you conduct due diligence. You want to find out whether you're actually buying genuine titles, genuine logbooks where you're buying vehicles. So you have to conduct due diligence, and usually you will have to have it as a clause in your term sheet, because due diligence has to be facilitated by the target company. In fact, as we'll shortly see, there is a document called disclosure letter, usually prepared by the target company, and includes disclosures. You tell me about your business, but the primary responsibility of an acquiring entity in this country is to conduct due diligence before you even proceed and discuss the final deal. You could equally have things like confidentiality in your term sheet. You don't want the details of the transaction disclosed. And because a lot of information is being exchanged, even in terms of our employees, even in terms of our trade secrets, even in terms of how the nuances of our business, like during that transaction, you learn a lot, regarding the two. Everybody learns a lot. The acquiring and the acquirer, the acquirer and the target, both of you learn a lot from each other. You get a lot of info from each other. A lot of info is exchanged, and therefore, goes without saying, your term sheet has to have a confidentiality clause, because, okay, you could have a separate an NDA, confidentiality agreement, but it's an important clause. You don't want this party, once things go south, to start telling people to uko Twitter ati hii ni credit ya free, sijui weka hash, weka nini, unajua, because you've already learned how airtime is made by your acquirer, who may be chucked out of the deal. And then cost means who will pay. You see, in this entire process, there is a lot, in terms of legal, there is a lot being done, including filling those forms, the merger notification forms, preparing your audit reports if you don't have audited ones, doing a proposed, that proposed breakdown of employees. You could involve experts. You could involve professionals to do that for you. So who's going to cater for attendant costs, which are relevant to a transaction? You could equally have governing law, of course. Governing law, if you're merging with, it's a cross-border transaction, you know how arbitration usually has seats, you will decide that you want the law of Uganda to apply to us and not the Kenyan law. But you could decide which law you want to apply to your transaction. And equally, you have to seek advice. Most importantly, you have to seek advice. Negotiating parties, both of them, they have to seek advice, because a bad term sheet will have bad effects. You might waste your money. And a good term sheet, then it means your time, your money will actually be, you'll get results. You'll be able to recoup your investments if a term sheet is good. You see, at a good term sheet, because you say it actually has the terms for the final deal, it's not a final deal, but allows us to negotiate and see where we are going. If it's good, then it means the final deal will be good. But a bad term sheet is a bad term sheet. Your final document might be bad. So that's the first document, a letter of intent or a term sheet. Okay. Usually, well, it could also be called a memorandum of understanding. If you see a document like that in an exam, it's a letter of intent. Okay. It could be synonymous to a letter of intent. And then there is another agreement. There's another document called an uncircumvention agreement. An uncircumvention agreement is an agreement, you see, if I am dealing with you, I am acquiring you. Let's say it's butter shop. Butter is actually butter is still there. Sindio, but kuna siku it was a big, it was doing really, really well. I might still, I do not know. So butter has its industrial outlet in Limuru, I believe. So Butter Kenya, of course, it does shoes. So Butter decides to merge with even a marketing agency, decides to merge with Shoe Planet. So Butter Kenya is merging with, let's say, City Walk. Yeah, so those two are merging. Now, City Walk, the City Walk manufacture it make its shoes? I have no clue. But for purposes of this example, assume they don't, they just sell shoes. So Butter Kenya is merging, City Walk is buying Butter. Okay, so City Walk is the acquirer, Butter is the target. So an uncircumvention agreement is intended to make sure, you see, during that transaction, City Walk might find out where Butter gets its leather. Yeah, maybe Butter gets their leather from. Where do they get leather? By the way, where do people get leather from? You know, these things are not obvious. So wherever they get their leather, yeah, to make shoes, to make really, I might say something and then I'm slapped with defamation pleadings on Monday. So wherever Butter gets their leather, wherever, let's say from leather, tulikuwa tunasema huko kwa social studies, but leather is from cows. Okay, just ignore that. So where they get their leather, where they get their raw material to manufacture shoes, City Walk will know. Because remember, Butter being acquired by City, Butter has the responsibility of disclosing a lot of information, including their suppliers for raw materials. So an uncircumvention agreement prevents City Walk from jumping to the actual supplier, jumping for lack of a better word. So an uncircumvention agreement will state that even if City Walk knows where Butter gets its leather, then City Walk is not going to merge with that supplier of Butter. So it prevents the acquirer from jumping to the actual supplier where they find out exactly how you do your business, where you get your raw material from. So it prevents them from going to that person who supplies you with the material. Okay, so that's an uncircumvention agreement. Prevents one, of course, acquirer from, if they find out about where you get your raw material, where you get your product, prevents them from going to that person. You stick with me because it's me that you found, okay? And then the other document, so there is an uncircumvention agreement. The other document is called a confidentiality agreement, or an NDA. An NDA is an undisclosure agreement. So NDAs and confidentiality agreement, usually, of course, they're meant to ensure information is not leaked. Yeah, because a lot of information is obtained through private discussion, exchange of documents, and of course, if it is leaked, it could derail a transaction. Yeah, so it could have a negative impact on the business. If you start disclosing, you thought you eat, you eat imported fries at your favorite fries joints, then you find out, bana, ni za Nyandarua. If such information is leaked, you won't eat your fries. But basically, confidentiality agreements and NDAs, they make sure they're meant to, their purpose is ensuring that information is not leaked. That's the primary, importance of an NDA. And usually an NDA, it will define what is confidential. Not everything is confidential. See, publicly known information, for example, Safaricom is a public company. That is public information. There is no need of you, even if I tell people I am merging with Safaricom, which is a public company, then ideally it's not confidential. It's public information. So you could define what confidential is to your transaction, and what specifically shouldn't be disclosed to any third party. And then the other document is called exclusivity agreement. Exclusivity, oh, by the way, on confidentiality, CAK has a standard confidential form. You can inform CAK not to disclose your info as well. So the duty to not leak information extends to CAK when you're submitting your merger notification form. You could submit together with confidential form and tell them don't disclose my information, because equally CAK learns a lot from the transaction because they have a lot. They have all those documents with them. They could actually again derail a transaction if disclosed even by the authority itself. Okay, so for exclusivity agreements, this is where it prevents the target company from negotiating a sale with another potential company during a particular agreed period of time. So exclusivity is meant to ensure that no one between you're not talking to other people, just focus on this transaction. So usually, because parties don't have to worry about flip-flopping and during negotiations. So this is it. Yeah, this is my person. I'm the one who's acquiring this company. So it remains exclusive. Like, you're not allowed to talk to other people and entertaining the thought of actually them acquiring you, or you getting acquired by them. Yeah. So you're going to remain loyal like a puppy. Okay. During the negotiations up until when the offer closes, or the duration for exclusivity lapses, and now you can entertain other persons who are desirous of purchasing your shares. And then the last document is called a disclosure letter. So a disclosure letter is usually prepared by the target entity. So a disclosure letter is good for the target company because it limits liability that might arise and acts as a source of information for the acquirer. You see, if I tell you, by the way, bana, hizi gari zenye unaona hapa za hii kampuni yote tumechukua MPSR. We registered notices in the movable property, that movable property registry. They're encumbered. We have borrowed from KCB. We have borrowed from Equity. We've borrowed from all money lending institutions using these vehicles that you're seeing here. If such information is disclosed in a disclosure letter, of course, if you find out later, this vehicle has totally, you can't even dispose it, or you're not getting any money from such disposure because it's heavily borrowed against. Yeah, you come back to me and tell me I didn't tell you because I disclosed that fact in a disclosure letter. So God, this rider will call me 40 times. I have his money. He took a letter to town. He keeps calling me. Yeah. But I'll deal after the class. Yeah. There are so many interesting characters out here. Very, very interesting. Anyway, so exclusivity. Disclosure letter. It will actually limit your liability as a target company because you'll have already said that which you need to say, and therefore it means whatever that other person finds out and you already told them, they can't come back to you and tell you didn't tell them because you already told them. And then on the part of the seller, the buyer, the acquirer, they're able to get information because it's a source of info. So a disclosure letter is important for both parties. One of you will limit the liability on the part of the target company, and then on the part of the acquirer, they get a lot of information in terms of disclosures. So disclosures can be specific and they can be general. So there are those two types of disclosures: general and specific. General disclosures, this publicly available info. You see, honestly, I know you're a public company, or for real, I know your directors is number one, Chepkemoi, and your other director is Othiambo. Therefore, that's public because you can find that in CR12. Like it's public info. But I don't know. We all used to know Bob Colimo. I don't even know the name of that new guy. Yeah. So we all know who's the MD of a particular company. So if you tell me the MD is XYZ, we already know. So it's a general disclosure because it's publicly available info. I can easily find out for myself, even if just like the patent and latent defects in conveyancing. Yeah, I can easily find out for myself if I just do a casual research on the company's registry. I'll know who your director is. I'll know where your physical address is. Like I'll know from that so even if you tell me it's general because it's publicly available info, it could be specific disclosure, which now it's linked directly to the company at hand. And if it's a specific disclosure, then it means this is not information available publicly. So it could be something like especially for private companies. For private companies, you know, no one really knows your affairs, yeah, because it's private, yeah. In fact, if there has been a change in directorship, you need to inform the company's registry. But sometimes, more often than not, no one. You should do it. It's a statutory mandate, but you might need to tell us, have you changed your directorship in the recent years? You might need to tell us, you know, what sort of business do you exactly engage in? You see, because your memorandum, your memrat, your articles and memo, they're not public information. So those particular details, or maybe you have a case against you, like you've been sued in 13 civil cases, you have some agreement with some suppliers, you've never satisfied your obligations in the agreement. No one knows those details because they are intricate. They are very I want to say personal to the company, but they are very specific to the company. No one knows unless the company tells you. Okay, so that's a disclosure letter. It's actually mandatory in due diligence, and you can be liable as a target company for material facts not disclosed. You can be liable for non-disclosure or for materially misleading information. Yeah, so you have to give the correct info, and equally, you have to disclose everything that the buyer needs to know. And then, yeah, so those are the documents. Okay, not too many. There is a disclosure letter, a letter of intent, non-circumvention agreement, confidentiality and NDAs. There is exclusivity agreement. So those are the documentations that you will find in during your merging. So very briefly, we'll discuss legal due diligence. So legal due diligence is the process of collecting, understanding, and assessing all the legal risks associated in the M&A process, the merger and acquisition process. So legal due diligence is, you know, due diligence is just investigating. You want to know what you're getting yourself into, because these transactions, it's not kidogo money. You might be putting in a lot of money. Yeah. So you want to make sure you're getting a good deal. And how you do that is by conducting proper investigations through due diligence. Okay. So the first thing you do to enable you cover base, you prepare a due diligence report. So you'll prepare a legal due diligence report, which basically is meant, yeah, please go on. Hey. Okay. Okay. I thought I had someone on mute. Anyway, so for your legal due diligence, because it's very wide and you want to cover base, you want to do everything, you'll prepare a legal due diligence report. So a due diligence report is a paper which outlines what you should cover, what questions need to be answered in terms of the intended merger. And the due diligence report will be sent as an internal memo to persons who are evaluating that transaction for purposes of closing the deal. So the due diligence report is basically, it's encumbered. God, I've had such a long week. Yeah, you know, I'm reading Commissioner of Monopolies as Commissioner of Odds. Yeah, things are bad. Yeah, so I share in your pain. I share in your pain. So a due diligence report is an internal memo usually sent out to everybody for purposes of enabling consequent discussions regarding the intended merger. Yeah. So we could quickly look at the sections of a due diligence report. So remember, legal due diligence is neither here nor is it there. It is very it's expensive. It has a lot. It's a more fast. It has a lot. So you do a report which enables you to cover your legal all aspects of your legal due diligence properly. So your due diligence report, which enables you to conduct a proper legal due diligence, could have the following sections, or rather, you could incorporate the following. Number one, corporate records. So you might need, actually you will need to look at the incorporation certificate. You want to know, is this a private company? Is it a public company? Is it in good standing with the state? And you are, you remember that saga for Mumias? You know, every time I remember Mumias, I remember it with so much heartache. You know, there was a guy when I was in campus, So this dude comes to class and he tells us that he's from Machakos. Actually, I might tell you his name, but okay. So this dude comes to class, and I remember. Actually, I remember that conversation very vividly. So he tells me and other guys that he has a farm in Mumias. He knows people with farms. He equally has a farm, and he does sugarcane. So he asks us that these are really good investments. It was very cheap. So he says he actually says he has harvested his sugarcane and usually sells to the local Mumias company, Mumias Sugar. So okay, sounds really good. So I indulge further after that discussion, and he actually tells me he knows very many people who are willing to lease their parcels of land. An acre was 2,000 bob for a year. Yeah, that was a red flag, So he says it's 2K per year. You know, there's some other three to five guys who are actually, they came on board and we proceeded to pay, you know. So we paid him. You know me, I told him, yeah, it sounds good. Let's get sugarcane. You know, it will be bought. He actually has ready market and ready farms and ready workers to work on the farm. But he was like, you know, he'll be going to watch over the crop. So very quickly, you know, that time in campus, you text your siblings, all of them. You tell them you want to print notes, something like that. You just text people, tell them, yo, there is an emergency, yeah. So the money I paid, I told him, Nisawa, let's do the investment because it sounds really good. So the guy goes down to Mumias. He actually traveled to Mumias because that is where his home is. See, the crop is being planted. So this dude, the crop is put on the soil. He sends a photo and he says, yo, guys, the crop has already been, it's put on the soil. The crop is on the ground. Haya, sawa. Tunasonga. Haya, kafika siku ya tunalima. Tunalima kwa kutoa, you know, weeding. Yeah. So, sasa weeding, tumeni do because okay, very quickly, let's text. Tumepata some kidogo money, let's send to the guy for purposes of facilitating farming, weeding. So weeding is done, he sends a photo. The farm is super good. And all this time, I think I was so stupid because he sends a photo. I can't see the crop moving from the soil. Like it's, Kwanza, first of all, he used to send a bare land, but he says, I bought it. So kidogo. There's a guy who paid that guy a lot of money. I think he said he wants 10 acres. So kidogo. This dude, see the crop, he had said the crop will mature between, we give it 7 to at least 9 months. So 7 to 9 months zimeisha, tumeenda long holiday, we are back. Sasa mimi nauliza mse nini imemea, miwa imemea, imekuwa, imeharvestiwa. Akasema sahi ndio hata wana harvest. And he sends a photo. Right now, another time he sends a photo of the actual crop. Sugarcane inakuwa loaded. Kwa an awaiting truck. So I'm like, super good. So let's wait for money. So we wait for payment because Mumia's company has to pay for the sugarcane. Acha nikwambie, I am waiting for that money to this date. And I think that guy never even planted any sugarcane. I don't think he put any crop on that farm. Yeah. So looking back and actually see him, I remind him that story and he laughs. So, well. Anyway, why was I telling you that? So you need to look at it was not relevant, but you need to look at the corporate records, including whether a company is in good standing with the state. There are those companies which you are honorable, you know, they wouldn't like it, or the local MP, local MP every single time in order to to gain some leverage with the constituents, he comes and tells you, mnaona hii kampuni hao ndio wanaiba miwa walipi, si ndio? Watu wanaklap huko wanasema ndio. If it's such type of a company which the locals hate it, they will abandon the mission very quick. So there's corporate records, includes the type of the company, generally who are the directors, does it have, what are the types of the shares? Are they ordinary? Are they irredeemable? Are they irredeemable? Do they have employee shares? What are the rights attendant to each class? What's the value of those shares? Such things, capitalization, if the capital is paid up for, or it was just allotted shares without paying, asking for money, and whether they need to call up for such. And then number 2, financial info. Financial info will range from number 1, how is this company doing? You know, so you might need to look at their audited reports, at least for the last 5 years. You want to see how it's been doing. If you look at a company whose assets, they have staggering figures in terms of debts. And then their assets as compared to the liabilities, their assets are actually almost negligible because the liabilities are so much, they're overwhelming. So you might need to reconsider the deal. You might purchase that company at 2 shillings because it has so many debts. So you look at financial info, you're able to see the assets vis-a-vis the liabilities and what type of liabilities those are, because you can renegotiate the purchase price. Usually tax details falls under the financial info. Does this company file tax? Ama ni uko Keroche, wako na mashida mingi with the tax collector. So you look at such because it enables you to, you see, you'll acquire its problems. That company, if it had problems with KRA, don't think you are running it. KRA will still come for you. Yeah. So you have to look at such issues. And equally, number 3, indebtedness. Indebtedness basically is the debt. You might have some agreements with some suppliers whom you didn't pay, or you have some debts from heavily borrowing. There's this company. No, let me not give any other stories. So because we need to finish. So indebtedness is how much debts those guys have. And then employment and labor, you want to see their employees, who are the employees, what are the details, the content of the employment agreements, if any. How do we deal with these employees if at all they're coming on board? Because if I was getting paid and my previous company, there is this, let me just tell you this last one. There is this guy, he was telling me, I know him as an old friend because I went to a primary school with him. Back in the day, a long time ago, before you guys were born. Anyway, so I went to school with him. So he was telling me, right now he works for a company called Oracle. Okay. So this dude, he has an entertainment allowance every single time. This guy works from Village Market. Yeah. Like he's never gone to that office. He works remotely. And he goes there, he'll eat oysters, he'll properly eat, and he'll drink. Yeah. So he was telling me that he has a daily stipend, a daily entertainment allowance of 50 USD every day. Yeah, and fuel. He gets fuel to go there. Anyway, so the point is, if you're such a person who works at Oracle, and then Oracle merges with Safaricom, there is no way you're going to remove my daily entertainment. It has to be there. So you need to look at the contracts because it enables you have a perception of how to consequently deal with employees who might come on board in the newly formed merger. You probably need to look at real estate or conveyancing. So real estate or conveyancing is what these guys have in terms of immovables, what properties they have, whether they borrowed to buy, whether they're encumbered. Remember, we were discussing conveyancing the issues of restraints in land, whether they have any cautions registered against them, they have inhibitions, they have restrictions, and whether it's possible to remove such. So you literally look at any agreement. Agreements basically means, you know, a company in the doing its pendency will enter into so many agreements with different people, with suppliers, with distributors. They might have franchise agreements, they might have joint JV agreements, they might have client agreements, they might have so many agreements, which of course regulates its contact with third parties. So you need to look at all these agreements and whether the obligations have been satisfied and whether there are any obligations outstanding, yeah, in those agreements. Number 7, supply and customer info. Lord, let me tell you, this is critical, especially where the company deals with, it's a trading entity. Trading means they buy and sell. So if you're buying and selling, or you sell things, why would you buy a company that has 0 clients? Of course, that makes the deal becomes unattractive. So you look at the customer info. Who are your clients? What is the volume of your sales? How often do you even sell? Especially if it's a company that deals with edibles, yeah, I think they're called edibles, like food, things to eat. Yeah. If it's like they do sausages, they do prawns, they do food, then they might need to have a very like, what is it, those people who come back to buy time and again, such customers, they need to have such. So you need to consider, who are your clients, what do you sell, how often do you sell, how much do you make from your sales. You probably need to look at legal aspect in your legal due diligence. So legal in this sense means whether there are any pending suits against the company. If it's a company which has been sued by 1 million people, and maybe in fact there is a pending insolvency petition, you are abandoned. So if it has so many civil cases or so many cases in court, so a lot of litigation, really it means the company, it will be a liability consequently. Yeah. You locally look at any governmental investigations. Do we have anybody investigating your business? You know, so if you're a business, unajua CID every single time they're snooping around. In fact, one of the time they came and sealed your premises, they asked you for CCTV footages because you might be conducting illegal business. So if it's such an entity again, then you could look at it with a keen eye and ask yourself, do I want to get into this? You look at all government licenses equally in your legal aspect. Government licenses include, this country, I think it's God, Lord, I don't even know where to start. Even a law firm, like the simplest of, law firm is easy to start, because if you need to register a partnership, it's 950 bob. Yeah, uko BRS. If you need to do a sole proprietorship, it's 950 bob. Lakini acha nikwambie, you'll set up shop. Those guys are usually on your neck for no apparent reason. Yeah. So you'll need, the only body that regulates advocate is LSK. So as long as you get a letter of no objection from LSK, you're good. Otherwise, anyway, you will need government licenses, a million. Those shops, they stick, like if you go to a shop, any shop, they have stack a million licenses on the wall, just in case anyone shows up. Yeah. So you need to ask them, do you have a license from Minadiara for you to actually conduct this business? And then environmental liability assessment, if any, and compliance audits. This will apply mostly to supermarkets. Yeah. There are those supermarkets wanashindanga huko City Court, but I guess City Court was moved to Milimani. So then they dump kila pahali, dumping, they are kila saa there is someone who's been arrested because of dumping by those NEMA guys, or maybe like really they don't comply with environmental issues, or maybe it's a company which does mining. So for mining companies or for big projects, companies which they're involved in big projects, you need to conduct an EIA, environmental impact assessment. So if that company doesn't conduct EIAs, NEMA is always there. They've been charged to call City Court for dumping. That's not a good company. Okay. So basically, that is what you look at in your legal due diligence. So your legal due diligence will encompass all those things that we've discussed. Okay. And then a due diligence questionnaire, you will equally need a due diligence questionnaire. So we're looking at a due diligence report. A due diligence questionnaire, as the name suggests, it's a list of questions. It's a questionnaire. So this questionnaire, it has questions which you answer. Yeah. So these questions, you're going to give them to a relevant party to answer for you. Okay. So your questionnaire might have number one, company information. You might need to ask, what is the liability in this company? Is it limited? Is it unlimited? You might need to ask any company information. Yeah. Number two, financial info. You might need to ask them, how much do you guys make? Or what liabilities do you have assets? Employee information. You might still need that to couch that in as a question in your legal, due diligence questionnaire. And then legal information. Everything else, unaona everything we've said upper qua legal questionnaire. Due diligence due diligence report unai repeat to hapo as in terms of questions. You'll just say everything else. Everything we've discussed, you'll say legal issues, any pending cases, litigation, agreements, employees, financial, everything. You say it can go into your legal, due diligence questionnaire, including intellectual property information, even if any, whether you're paying for the IP, if it has a patent, it has a trademark, it has a copyright, yeah, you might need to discuss such. You might need to have those as questions, ask them whether they have any IP, any protected intellectual property. And physical asset info, we've already discussed. You need conveyance, real estate issues. Ask them whether they have any immovables and what's the actual state. So your questionnaires, your due diligence questionnaire can cover any aspect here. Sindio, company, financial, any aspects can be covered in your due diligence questionnaire. So we won't restate this because you've already done it. So company due diligence questionnaire will have this type of questions. What is your organizational structure? What are your current bylaws? Can you provide a list of all subsidiaries? Who are your security holders? Where you've charged your property and you've used your property as a security? Who are your key players in the organization? What are their roles? Such questions in company due diligence, because you want the company, the corporate information, what you call it, corporate information. And then number two, financial due diligence questionnaire will have issues of finances. What are your operating costs? Yeah. What do you budget and operating plans consist of? What tools do you use for purposes of budgeting? What are your accounting policies? My good Lord. I hope you're drafting those things. You're doing those accounting things. I almost getting PTSD. That mathematics, Uko LPM, let me tell you. Now, I struggled. My good God. I didn't buy a calculator because I was wondering, sasa, ni ya kuhesabu nini? So I actually borrowed a calculator. Anyway, so that mathematics for accounting, there's a guy called Suka. May God bless his soul. My God, he saved me. I was in a dark place. I was in the bottom of the barrel. So, that mathematics, I'll ask him where he is nowadays. I can ask him to come and show you 1, 2, 1, 2. He has really, really good. And then he's a certified public secretary. So he knows a lot of mathematics, a lot of those accounting maths. Yeah. So he simplified it. If I understood that mathematics, everybody can understand it from that guy. He was so, Lord, I should look for him. Sindio, I buy him coffee. Okay, I ask him where he is. I don't know where he went. It's a long time since I spoke to him, but he was my farm member. We were in the same farm. Yeah, I'm not sure. I'll call him. So if he's available, I'll ask him one of these fine days to tell you what he told me. Because of course, I remembered it during those 2 hours and then forgot immediately after. Yeah. So I'll get him for accounting. So you could ask their accounting policies. You could ask their investment policies. You could ask in terms of finances, like anything finance, anything money. And then you could have an employee due diligence questionnaire. Yeah, you're asking about the employees basically. What do your current employee contracts look like? Like how much do you pay them? Do you pay them $100 per day for the entertainment, or exactly how do you deal with them? And then your legal due diligence questionnaire, this is what you've already discussed. Yeah. You could have a product due diligence where the company deals with products. You can ask them, what specific products do you offer? Who are your suppliers? So where they find a supplier, they're not supposed to jump to the actual supplier because you could have a non-circumvention agreement. Remember, okay, consumer due diligence, you could ask them, who are your customers? These are easy things. So what you need to remember, really, if you ask me, is this list, like what form, what areas could you have questionnaires for? Yeah, you could have questionnaires for company info, financial info, employee information, legal info, product info, consumer info, IP info, and physical asset info. Rather, those obvious information that you might need while you're acquiring a company. So we've already discussed a disclosure and disclosure letter. We've said that usually it's sent by the target company, disclosing every single thing, not every single thing. They could have those important aspects regarding the transaction. So it discusses these notes, further discuss the contents that could go into your disclosure letter. Okay. This is in the course outline. Let's discuss this very quickly. Asset acquisition. You remember when we were discussing mergers, we said it could be purchase of an asset. You could buy asset. So asset acquisition basically means this is where the acquiring company purchases assets instead of shares. So they decide to purchase your assets, your vehicles, your immovables. Yeah. So the factors that you take into consideration, or rather, the content of your asset purchase agreement, you remember that purchase and sale agreement you take to CAK, yeah? So that agreement will have there's some contents here. Part of an asset purchase agreement could have your recitals. Recital is that opening paragraph, yeah? ABC PLC has agreed to purchase herewith all the assets, movable and immovable, fixtures belonging to ABC Company Limited. So that's the opening paragraph. The recitals could have definitions, could define terms in your asset purchase agreement. You could equally have of course, you'll have the purchase price, goes without saying, because you need to know how much are you paying for those assets. And then you might have closing terms. Closing terms includes the closing date. Remember, an offer cannot remain open for too long. So you could have a closing term. You could equally have warranties. There's something we used to say. I think it was, what unit was that? What? I don't remember. It was called Law of Contract 101. Yeah, something like that. There was a distinction between a warrant and a condition. One of them was binding, the other one wasn't. There was such a thing. Yeah. Anyway, so warranties will go into your asset purchase agreement as well. So warranties basically one party promises the other that these assets are not encumbered, they're in good condition, perfect working condition. They've only used it for 6 months, So warranties are those promises that you tell the other party to make them feel good. And then covenants on, I think, by the way, what were we saying? I don't remember, honestly. By the way, that guy who taught me law of contract, they imagine they passed on. They had cancer. Imagine. Yeah, I was so sad to learn that. Yeah. Ebu check online the distinction between a warranty and a condition. They should be, one of them is binding. Sasa sikumbuki.
Conditions are binding, warranties are not.
Oh, okay. You see why I need you. Yeah, warranties are promises, they're not binding. Covenants are equally, covenants are rights, duties of parties. Yeah, covenants, we could say covenants on the part of the buyer, the target company, covenants on the part of the acquirer. So those covenants are basically obligations to be met by the party. You could have indemnification clause, which basically protects both parties, the acquirer and the acquired, yeah, in the event of a legal dispute that you see, for example, if I disclose to you regarding my assets, I tell you those assets, I don't tell you they're in bad condition, but I tell you, there is a dispute, those properties are not in good condition, those vehicles are in and out of the garage, they have a really big problem, we have not even insured those cars, so I tell you such things in my disclosure letter. Then it's important to have an indemnification clause. Yeah. For you promising me whatever happens regarding those cars, if they cause an accident, if they break down in the middle of the road, then don't call me, because I am indemnified against any issues that arise from use of those assets since I disclose. So indemnification protects you. both, everybody, yeah, from any ensuing legal disputes, as long as you have disclosed. And then governance means the law that will apply to your contract. Yeah, I could say Kenyan law, and then it has to be dated and has to have signatures. Everybody has to date. I mean, you have to sign. Everybody has to execute it. For any agreement, yeah, under the Law of Contract Act, it has to be signed. That's the only way you're able to show your intention to be bound, yeah, by appending your signature. All right. So that's an asset purchase agreement. That is what those are your content, those are the content, or I'll share with you a copy, but that's basically what will go into your asset purchase agreement. You equally need to very particularly tell us what assets you're buying. If they are cars, sometimes you might need to tell us, if you might not be buying all of them, exactly which ones. If it's furniture, tell us exactly which furniture. Like, have a vivid description of what you're buying. It should be ascertainable from your asset purchase agreement, because a company could have a lot of assets. Yeah. So asset purchase could include purchasing of a license, purchasing of intellectual property, purchasing of equipment, machinery, purchasing of a business as a going concern. You go purchase anything as long as you're not purchasing shares. Okay, not anything. Yeah, but it's an asset purchase agreement if you're purchasing any of these things, of course, which it's actually, if it results in control, then it becomes a merge under section 4.1. Okay, so let's stop at that. Cynthia, do you have any questions now? What remains? Just let me check the course outline. So an asset purchase agreement is an agreement which basically formalizes the transaction where an acquirer is purchasing assets instead of shares, and it has all those assets: the purchase price, assets being acquired, indemnification clause, has covenants, has warranties. And then I'll need you guys to go through these notes. Yeah, of course, I have tried my best to say everything that I think is important. But there is something else. It's a lot, admittedly. So I'll need you to look at a few things. I'll need you to read Takeover. There's something called defenses to a hostile takeover. And also, so maybe write them down, and then you look at them. Cindy, but once you get a chance, we'll discuss them. So defenses to takeovers. Sometimes a takeover can be hostile. And even a merger can be hostile. So it is hostile because you don't want to be acquired, but there is an offer nonetheless. So when it is hostile, there are some defenses which a company can use. Number one. So look at the defenses to takeovers. I'll share a document with those. And then equally, look at reverse takeovers. If you go to that CMA document, CMA regulations, they have what a reverse takeover is. A reverse takeover is when a smaller company acquires a bigger one. You see, ordinarily, it's a bigger company acquire. Imagine Airtel acquiring Safaricom. So reverse takeover is those instances where a smaller company acquires a bigger one, and it enables sometimes a private company to get publicly listed in a short period of time. It's called a poor man's PIO. IPO, initial public offering. Yeah. So I'll share notes on reverse takeovers and defenses to takeovers, but you need to look at those two things. Don't forget. Cindy, what else? Okay, and then types of mergers. That's the other thing. Types of mergers. There are quite a few. Yeah, there's vertical, horizontal, absorption, but I'll share a document with those. They're important. They enable you understand things. An examiner might not ask you what is this type of a merger, but it might enable you to get an answer to a question which looks complex. So usually for questions, you'll start. I want to get the course outline, see whether we've done everything that's here. Okay, so mergers and acquisitions, we've discussed what a term sheet is. We've discussed exclusivity agreements. We've discussed confidentiality and NDAs. We've discussed legal due diligence. We've discussed questionnaires, what questionnaires you could have on different areas. And we've discussed a due diligence report. We've already discussed the content, the part of a due diligence report. We've discussed a disclosure letter, which is done by the seller, by the seller, target company. We've discussed asset or share purchase agreement, the key considerations. Key consideration is basically the contents, yeah. And then we've discussed the key terms of asset purchase agreement. We've discussed warranties, indemnities, completion. We've discussed notifiable mergers. That's the first thing we did. We discussed what is a notifiable merger. You remember 100 million. And then non-notifiable mergers. Lord, equally look at COMESA guidelines, COMESA threshold. They're almost similar to CAK, but you could look at they might not be substantively examined, but you may need background, like tu kidogo tu. Sindio usikwe too blank about COMESA guideline. You've never opened it, so open it and look. Just one cursory look is enough. No one will test substantively on COMESA, but you need to know what it is because CAK guidelines allude to it. Sindio. So don't forget what a notifiable merger is. Non-notifiable merger is that merger you need not notify CAK. The one no notification at all, and the other one for exclusion notification, and the prescribed forms. You go to CAK's website as you check out whether they have pupillage positions openings, and then you look at, there is a form called confidentiality form, and then there is the merger notification form that I've shown us, yeah. So we've looked at the merger notification form, confidentiality claim form. Iko kwa website okay, unaziangalia. So if you look at this, we've discussed everything here. If at all you're required to do any question on mergers, it will be something we've mentioned today. You know, I can tell you that for sure, like 101%. If that question is there, it is something we've said today. It's not anything we have not. It won't be strange. That's my point. Yeah. It will be something you've had with your ears. So you might want to maybe go back to those slides uziangalie tu kidogo tena. Sindio? And equally don't forget the merging process. That's very important. Sindio? So if you check now, because that's what we said you will do. Sindio? You read first, and then you go to the course outline, you tick everything that you've read. If you see something here, unaonapa confidentiality claim form, you have no idea how it looks like, unaenda unaangalia very fast. You might be asked what are the contents of a confidentiality claim form. So unaangalia notes first, you read them, you understand, and then you come to the course outline, look at whether you've read everything on that topic that is on the course outline, and then you check, you get a past paper question. So this is what you'll do. Trying to remember where I saw that question. There are quite a few questions on mergers. This should be the paper that was done in March. Yeah, it should be that March paper. So after you read, you go to the course outline. Ukiona kitu kwa course outline inakaa strange, ujawai soma, it's new to you, you have to read. Not even if you're not reading it sana, just have an idea what a merger notification form is. You can't, if that thing is on the course outline, you can't afford not to know about it. Albeit, you know kidogo. So you will after doing that, after reading course outline, you're good. You go to a past paper question. This is a match. This was the paper that was done. These guys that were at KSL before you guys joined. So it's usually the last paper, ATP 108. So you scroll up. I don't remember where exactly it was, but I know it was there. This first question was on JV. Here. It's actually question 1. Hii story ni refu sana. But kuna company mbili, there is Alpha Kenya Company Limited. If you see LTD, it means it's a private company. Even without reading anything else, it's a private company. Because Section 54 of the Act mandates any private company has to end with the words LTD. Yeah, you're told it's an unlisted company. Without even thinking, you would apply CAK. You don't apply CMA because it's unlisted. So, you will read that story. Oh, there is a board of directors. Oh, they want to do something. Oh, company structure. They want to restructure. You see, such things. And then you're told they want to acquire a Ugandan company. It's called Indaba Mining Limited, and they're in the sector of manufacturing equipment for mining sector. What does our company Kenyan one do? Mining. What do they mine? If it's carbon-based, you remember those issues of carbon-based. Sindio? So you read between the lines, underline what's relevant. They're acquiring companies in Uganda and in Ethiopia. Those both are COMESA. So COMESA, I think you have to remember that list as it was first of all. Sindio? For you to know where this category is, whether it's the one for full merger notification or exclusion. So you asked first question asks, should Alpha Kenya decide to proceed and negotiate a merger with one of the foreign entities, typically what documents will the company be expected, Lord, to execute during the initial preparatory stage of a merger? So you would answer these documents without batting an eyelid. This chick who did this paper was my student. Yeah, you see, I think she remembered them, how we had discussed them, but she forgot one. But right now she's a pupil at the farm. And then part 2 asks, advise Alpha on jurisdictional threshold for notification of M&A, explaining whether there are any exceptional circumstances in which Alpha may be exempted. Good. See, this one you will discuss, nakumbuka those 3 categories, all of them, but now in the context of Alpha, that company. And then you asked JV, that's JV. That's JV is to be found in the topic called commercial agreement substantively. Yeah, and then you asked, advise Muhatia on the risk and benefits of the parties agreeing on a letter of intent and whether Nawiri should proceed and sign the draft letter of intent. Lord, I think this is doable, extremely doable. You see, it sounds familiar. Like if you read the question well, you have the answer. But then everything that will be on that, I don't know how to put it in your seriously. Lakini, everything that will be on that paper on mergers, you've had it today. So your only responsibility is to try and remember what you had. Sindio? Sawa. So let me stop projecting this. Guys, you'll allow me to end the call now, Sindio, because we have a trial advocacy tomorrow the whole day. So I have to rest early. I have to fix a plate, eat, and then rest early because I'll have to wake up early, and I don't love mornings. So I have to sleep early for me to wake up early. Sindio. So do you have any question? We could unmute, ask. You could ask. If we don't have any questions, allow us to end the session now. Sindio. If you have any specific questions, you could always DM me. By the way, Lord, I have
a question.
Yeah,
my laptop is a bit slow. I'm sorry, my laptop is a bit slow. So in exam, can we be told to draft an asset purchase agreement?
Everything is possible as long as it's in the course outline, and especially that course outline says here, it tells you have to remember the key terms of an asset purchase agreement. So it means it's a draftable document. It is absolutely 100%. Yeah. Guys, in that last, it should be November, the paper for last year, the receipt for last year, they drafted this question 1, distributorship agreement. So you can draft anything as long as it's on this course outline. Yeah, sweet. Happy tool to draft it. But as long as you remember the clauses, you can draft. Yeah. So we kumbuka 2 clauses because it's a standard agreement with a recital, and then it has definitions, it has purchase price, assets being purchased, it has duties and rights, such things. It wouldn't be hard, but it's true. You can be told to draft it. Very true. Okay. Sawa, do you have any other question? Hi, Sawa. Seems we don't have any other question. Guys, thank you so much for the indulgence. It's always appreciated. Guys, they say you have to find something that makes you happy. Yeah. You see, you guys, I think this is it for me. I wanted to stop it because I have a lot on my plate. I didn't have a lot last year for the last cohort, but this year I have a lot to do. Responsibilities have increased, So I wanted to stop, like entirely just stop, not do it anymore. And then I was like, I think this is my calling, You don't abandon the righteous path. Yeah, so you have to find that which makes your set your soul ablaze. Anyway, thank you so much, guys, for the indulgence. I'll see you tomorrow. Have a lovely night and a restful one. at the same time.
You as
Thank you.
well. Thank you.